call to order the 163rd meeting of the Massachusetts Gaming Commission, again at our offices on Federal Street. First on the agenda, as usual, is the minutes. Commissioner McHugh.
Mr. Chairman, the minutes of the September 3, 2015. Oh, there it is. Thought that little green thing was winking at me. The minutes of the September 3, 2015 meeting are in the book, and I'd move their approval in the form they appear there with our usual reservation of the power to correct typographical and mechanical errors.
Second?
Second.
Any discussion? All in favor? Aye.
Aye.
Opposed?
One abstention. I wasn't present for that meeting.
Okay. Commissioner Zuniga abstains. All right, next up is Director Wells, at the moment as interim executive director.
Thank you. Good morning, Mr. Chairman and members of the commission.
Good morning.
It's a preliminary matter under the general update. I'd like to turn the microphone over to our CIO, John Glennon, to introduce the newest member of the Massachusetts Gaming Commission.
Thank you, Karen. Commissioners, it's with...
John, hang on one sec.
Sure.
Do you hear back there okay, Kevin? Is that okay? Great.
So it's with really great pleasure that I'm going to introduce to you this morning our new manager of gaming technology, Floyd Baroga. Floyd comes to us from Williams and WMS Gaming as in a number of roles, including senior jurisdictional engineer. He worked on the manufacturing line for slot machines and has worked in iGaming and various parts of regulatory matters for a manufacturer. He spent his first week at Plainridge, and we're very pleased to have Floyd on board. It's been a long process to get him here, and very happy to have him here. Floyd?
Well, thanks, John. I just want to say thank you to the Commission for the opportunity, and anyone that I have come into contact with has been extremely kind. So thank you for having me here. And this week I was at Plainridge viewing the process of the field agents and the daily verification of all the slot machines. And Bruce's team has done a great job with those machines and ensuring that those machines are in fact validated and tested identical to what was evaluated by the independent test labs. So thank you for having me.
Great.
So,
Welcome aboard.
no, thank you.
It's good to have you, Floyd. Welcome.
Thank you.
Are you? I didn't get. Are you moving to get here, or are you living?
Yes, I'll be moving from Chicago to Boston by the end of the month or early October.
Great. Welcome.
Thank you very much.
Thank you.
Welcome, Floyd. The next item on the agenda, I'm going to turn it over to Commissioner Stebbins for an update on the executive director search.
Thank you, Director Wells. In the packet under tab 3A, you have a number of documents. You have the posting which we approved at our last meeting 2 weeks ago. I'm pleased to report the position has been posted with the help of HR Manager Vanda. Is now up on the state website. With her help, we put together the first memo is reflective of a strategy and the tools and the resources we're going to use to post and promote the position. This process does mirror our first search, and that one commissioner was assigned to lead the process, and that is near the rear of tab 3A. We'll go through some of the highlights again. This process will begin with the postings. You'll see highlighted again in the attached memo that I had great assistance from HR Manager Vanda in putting together, talking about where the position will be promoted. We are not using a search firm this time. I feel we have an HR department, which we did not have the last time out, that I feel will help with the screening, the reference follow-up, the promotion, the handling of the resumes as they come in. We'll also, I think, be using the context we have culminated amongst the five of us and among our directors and our team over the last 3 years to get notice of this position posting out. We're going to reach out to executives in other jurisdictions, our consultants, gaming experts who can share information about the opportunity. We have also expanded the search this time beyond gaming professionals and included experienced executives who have a background in enforcement or regulatory management. A second new element in this process that I want to highlight is we begin to screen candidates and bring candidates in. We are going to afford them the opportunity to sit down with our senior management and our directors. It's going to give our candidates a chance to learn more about the inner workings of the commission. It's also going to give our team the opportunity to help our candidates understand our priorities and share with them their responsibilities. At the end of this process, again, our goal is to have multiple finalists for the commission to interview in a public meeting. My hope is we can approve this process today after some discussion. Catherine, General Counsel Blue and I have talked about the fact we'll share this process with the AG's office. We have a new AG in place. The old AG gave some review to our process the first time around. The last time we decided that final interviews need to be conducted in public. We did hear along the way that might have been a deterrent for some candidates. It's my understanding there isn't much way around that in light of the public meeting law, but I'm happy to answer any questions you might have about the process as we presented it in the book.
Anybody?
I had a couple of questions. What factors went into the decision not to use a search firm? I know that the last time around we had, when we were doing a lot of hiring for various positions, we had mixed results with search firms, to put it mildly.
Right.
But the best that we got out of those search firms was a entree into a Rolodex of people who might not otherwise have been interested in or who might have heard about our positions and an outreach to those people to see if they'd be interested. I recognize that we do have a good HR group now, and I recognize that a chunk of what the good search firms did last time could be done in-house this time, but it's the outreach piece and the encouragement piece that I wonder if we aren't losing by not having a good search firm.
It's a valid point. Again, I would point to the fact that we've expanded our reach. We are not just looking at gaming experience. Part of it is having the HR department, which we did not really have staffed to its full potential the last time around. And I think to the degree that all of us, including our executive team, have really created relationships in other jurisdictions with other gaming executives, are just relationships that we built being one gaming jurisdiction. I think reaching out to those folks, I've already heard from one individual in another jurisdiction who was aware of our posting and had a candidate or two that he would recommend apply. To the degree, to your point, the idea of kind of ginning up interest in doing that deep dive into finding people, I'd like to see how this goes and think I'm pretty confident we'll be able to find some good candidates through those relationships that we've had, not to mention, some of the just public or some of the other resources where the job will be posted.
I don't want to beat this, and I respect that and understand that. On the other hand, the contacts we've made and the places where we're likely to reach out to are likely to be within a relatively narrow confine. I'm thinking of the person at some university who's got a major administrative position and who's thinking of leaving, somebody who's working for a construction company that is thinking of leaving, somebody who's working for something that has nothing to do with gaming and that our contacts would not likely know about. We conducted a nationwide search last time, and it was a good search. This is such an important position that I just wonder how we'd find those people And maybe the wealth of people in the areas where our searches will likely reach is going to be sufficient. But so that's what prompts my question.
You know, I would argue that that's a tool that we have at any time, really, going with a search firm. And I think it's a good policy to try just what we're doing now, which is try to look at the existing infrastructure here with HR and others. And if we're getting very little interest, for example, or a field that appears to be too narrow, we could always reevaluate.
Yeah, that's certainly true. Time is another issue. But I hear you.
The two examples that you gave of somebody from a university or someone from a construction firm are probably not viable, I mean, within our job description, because we have said either gaming experience or other kind of regulatory or enforcement experience. So,
Is desired,
well, maybe, yeah.
right?
I forget which was that.
They're not minimum, they're not mandatory.
But I think that's a pretty long stretch. Sometimes for administrative positions that don't have any specialty knowledge, you know, you can bring in an outsider, a real strange outsider, like me. But
Like the four of us.
like the four of us, very strange. I just wanted to highlight two things. One is the role of the directors. That was a role that we didn't have. You all right, Mike? That was a role that we didn't have really in place last time. We also had the directors, our executive staff, very involved in the writing of the job description. So I think that's an important factor for everybody aware of, that this project really is very much done in collaboration with our executive staff. And the second thing is, and I mentioned this to you, but to mention it more broadly, last time you had a function of some outside people to work with you to do interviewing, because we couldn't get a group of commissioners to do it, so you tried to find some people who had somewhat kind of similar perspectives and experience and so forth to help you make those preliminary judgments. And I know you have that in here as something you might do. I really would hope that you could find somebody or two people who you could do that with. I think that's particularly the kinds of people that you came up with last time, that's a really valuable perspective to add to the mix.
Absolutely. It is my intention to use those, I classify them as stakeholders, but sometimes they're just professional executives that know the industry. I think the last time out, we probably did not engage our consultants in this process as much as we could. I'd like to turn to them, but the last time out, you're right, we used the CEO of an executive search firm who actually sat in on a couple of the second and third calls that I did with a couple of candidates to get his impressions. So we will look to do that again. If I said we may use it, I would change that to say we shall use it.
Okay, great.
Okay, I had one other question, and that is paragraph 3. What is the function of this phone screen?
The phone screen is a chance for us to, Dean from our HR department would be making follow-up calls, acknowledging we've received their resume, any questions they had about the position, put them through some basic questions. We've been preparing those and looking at those, giving examples of their work where they see it might fit, talking to them about the process, answering any questions they might have about the process. But we're finalizing that list of questions that the dean from the HR department can do with candidates that we think have a worthwhile resume to consider.
And what value do we gain from that? I ask this question because I wonder at this level if a telephone screen might not be a turnoff, to be perfectly blunt.
Okay.
However carefully it's done and whatever value it yields, this is a very high-level position. And without diminishing the role of HR and the importance of the process, I just wonder if that piece of it isn't conceivably something that would deflate as opposed to increase interest in the position.
Okay. Yeah, we've used this with some of the other various positions, but understand,
Yeah, I know.
I hear your concern. We
right.
definitely don't want to turn anybody off in this process. It might wind up being something that myself and Dean can do. Again, I would give us the flexibility to see how many resumes we get in.
Right.
And, if it's a small number, he and I might be able to find the time to do it together. If we get a large volume, it might be a good initial step. I think some of that will depend on, the volume of resumes that we receive.
Commissioners, I can tell you that the executive search firm, when I was interviewing for this position, did a phone screen on me. And I can tell you it's the type of questions that they ask that try to figure out if you're serious about the position. So I think what Bruce is talking about, making sure you don't have questions that turn them off that you would do to an entry-level position, but try and get a understanding of where this person is coming from is pretty essential. And it didn't turn me off. It actually showed that someone had an interest and was doing a
Yeah.
thorough search for the company.
I get that, and I appreciate that. And I know that one of the search firms we used did that as well. But they did like a 2-hour, in some cases 3 or 4 hour interview before they came in. I take it we're not. Well, I guess what I would just, I've made my point, and I guess what I'd like to see as part of the screening process is a sales pitch for those who we determine are in the pool, because it's a good opportunity to emphasize how exciting really this position can be and what the next steps are going to hold, and the ability to be creative and use it as a selling tool as well as an information gathering tool.
Absolutely.
Yeah, I'm really glad you brought that up, because it was bothering me too, but the thought hadn't crystallized. And now that you framed it, I realize that I was a little bit troubled by that for much the same reasons. If it's not done well, there is a risk, and I've felt that sometimes. Routinely, search firms, do have a more junior person give even pretty senior candidates a sort of a screening call. Maybe you could talk to this sort of as what is the practice, Trupti. But I want to make sure that we see the questions, and I think, it ought to be done thoughtfully as the resumes come in, think about them, separate out. Maybe there's some we don't want to do that because they're so obviously legitimate candidates. I think it's something that really a good point to be sensitive to. But go ahead if you want to.
So the process of the phone screen is to just get an overall layout of the candidate's background. But in addition to Commissioner McHugh's point, is to sell them on the opportunity that speaks beyond the job description. And also it's to include candidates rather than exclude them. So the idea would be we have a list of 20 candidates who we're interested in, or if we had to pare it down to 10 candidates who we can bring in, let's phone screen the 20, because the logistics of coordinating interviews and availability would, span over, weeks and months, given everyone's schedule. So the idea would be to start the dialogue, have an understanding of their background, talk to them about the opportunity, the direction that the agency is going in, and so on and so forth, as we move forward with the next step in the process, which is to bring them in. And then once we
Right.
have that information beyond their resume and the candidate having a deeper understanding of the position, so it's more of an informational opportunity for both parties.
Right.
Okay.
Can I mention something that you described, and I really hope we can get 2 or more finalists to come to the commission. I know that may be a deterrent for somebody, but it would be my preference if we could have before us, after everything that you describe here, and just like you say, have a couple of candidates or more to choose from, to be able to vet and all agree on.
That would be my goal.
Any other discussion? So with this kind of flavoring, we'll go ahead. Thank you, Commissioner.
Thank you.
Thank you.
The next item on the agenda is the performance management process. You know, as I think is, probably everyone in this room is aware, no agency, the agency is as good as the team and the staff that support it. And I think we're very fortunate in the MGC to have an extremely strong staff here. And I think Director Band is going to go over the process for the performance evaluation that we've implemented.
Good morning, Commissioners, Chairman.
Morning.
Morning,
Um,
again.
I'd like to walk through our process today and sort of the methodology we've used, working collectively with the executive team to craft the process and had deeper conversations around. So on June 30th, 2015 marked the conclusion of the fiscal year 2015 and the last 12 months of performance period. All regular employees who were hired prior to April 1st of 2015 are in the process of participating in the performance review process, which includes a written self-assessment, manager assessment, development plans, and performance discussions. The purpose of this memo is to seek your approval of the process and methodology applied for the merit increase based on the results of the performance reviews. In the fiscal year 2016 budget, a 3% pool was set aside for merit increase awards and an additional 1% pool for a one-time lump sum payment to recognize outstanding performance throughout the year. So this was done during our budget process earlier through Derek, our CFAO. My recommendation for the methodology to distribute this pool is as follows. Merit increase decisions will be final on October 2nd, 2015, and the payouts will be distributed on October 23rd, which is our next pay cycle following the 2nd. All employees hired prior to April 1st, 2015 have been and will be reviewed for the merit increase. Eligible employees must have completed performance reviews in order to be considered for an increase. Employees who were not eligible for an increase last year due to their hire date will be eligible for an increase retro to their one-year anniversary. Employees who are hired after March 31st of 2015 are not eligible for a merit increase until next year. That's our 90-day probationary period. They've just joined us, so it's a little challenging to review, so they'd be eligible for the next review cycle. Employees who receive an overall rating below consistently meets expectation will be placed on a performance improvement plan and will not be eligible for a merit increase. Employees who receive a equity or a market adjustment and a promotional increase in fiscal year 2015 may be eligible for a merit increase. Decisions will be based on an individual performance as well as the timing and the amount of the last pay increase. Managers who nominate an employee for the one-time payout pool must provide a justification to a committee for approval. So the committee will be made up of members of the executive team, and they will be reviewing a justification for the approval for that one-time adjustment. Additional equity adjustments will be considered on a case-by-case basis. Human Resources will provide analysis and recommendation to the interim executive director for her review and approval. The analysis will include consideration of relevant benchmark data, the adopted MGC salary ranges, and internal equity. So with that, I respectfully seek your approval for adoption of the merit increase process and methodology outlined above. Any questions?
The 1% pool is to reward particularly meritorious performance, right?
Correct.
And so it's not necessarily so that the entire 1% will be utilized every year.
For this budget year, 1% has been allocated, perhaps.
No, I understand the allocation is
Right.
there, but we're not committed to giving out the entire 1%. This truly is a premium for exceptional performance, right?
Yes.
Okay, and everybody will understand that. All right.
And
Correct, and
it's a one-time, it's not an additional pay raise?
Correct.
So
So what
it's a
we're trying to
bonus.
do, yeah, so it's essentially a bonus, and there's an object code in the state payment plan. And what this allows is for you to recognize someone
Right.
for a good contribution and not permanently increase our bottom line.
Right.
So you're just throwing it in this one time. I think it's what you see a lot of different areas moving towards, so that you can recognize yet not hurt the bottom line and continue
Right.
to build the salary base up.
Right. And I think it's a great idea, as long as it's understood that it's. not
Correct, it's
just
set aside,
Right.
doesn't mean we have
Right.
to spend it.
Right.
What does that come to? What is 1% of the, more or
I
less?
think we had a $5 million base, so it's probably 50,000,
Okay.
which can be eaten up rather quickly if you get four or
Right.
five people.
Right.
Okay. Anything else on this topic?
Do we need a vote on this, or is it just,
No,
No.
it's part of the budget, it's part of the plan. We just, if you had anything that you objected to in here, any of the methodology,
Okay.
we'd want to hear from you before we went and implemented
Right.
this.
Right. Okay. Looks good.
I do have a subset of that,
Thank
please. In the packet is a memo from me relative to Director Wells' additional responsibilities. I'm recommending that we adjust her current salary to the midpoint between what we were compensating our prior executive director and where she is now. That turns, that would mean an increase into $175,000 a year for her during the period that she remains an interim executive director. This pay would go back to her increased salary of interim, of IEB director when we get a permanent executive director. I can answer any questions if anybody has.
I had one, but I think you answered it, which was, this ought to be something that is some kind of a rational formula that can be applied to other circumstances. And it sounds like what you did was decide to take the midpoint between the existing salary and the salary that the outgoing person made.
Right.
Okay, it's somewhat arbitrary, but you don't want to necessarily go all the way to the top because the person may or may not be qualified for that.
And we gave it a little bit of thought with the help of CFAO and HR director. Part of the consideration there is our executive director brought a lot of years of seniority and experience before. And frankly, I think this could also be an incentive for director to be thinking about future roles, perhaps.
Well, I
If
think it's
she'd
a
be
great
interested
idea.
in the executive director.
Just for the record, I think she well deserves it, so I agree. Does either of these need a vote?
No.
No,
No,
they're
the
already
funding
in the
is
budget
included.
and they're allocated, so I
Okay.
think you're fine.
All right,
Excellent.
excellent.
Thank you.
Good. Thank you.
Thank you.
Now we
Thank
through
you all.
A.
The next item on the agenda, Mr. Chairman, is under the Investigations and Enforcement Unit. Item A is the vote for the commission on the Key Gaming Executive license. It's for Michael Toma. In December of 2014, Mr. Toma was promoted to Vice President of Operations for Plainridge Park Casino in Plainridge, Massachusetts. Prior to that promotion, he was the acting general manager and director of operations at Argosy Casino in Sioux City, Iowa. He submitted all the required forms, supplemental document requests to the licensing division, and the IEB and investigators conducted the normal rigorous background check, including his employment history, criminal record, education, references, media coverage, political contributions, directorships and shareholder interests, civil litigation, bankruptcies, and property ownership, among others. Mr. Toma was interviewed in person by the IEB, state police, and financial investigators as part of the standard Key Gaming Employee Investigation Protocol. And investigators also conducted a financial responsibility evaluation, which resulted in a positive determination. Mr. Toma attended Bellevue University in South Bellevue, Nebraska, where he was awarded a BS in Business Administration in 2008. Prior to his current position at the PPC, Mr. Toma held several positions, including, as I've stated before, the acting general manager and director of operations at a casino in Sioux City, Iowa. Before that, he'd been a table game dealer at Firefly Creek Casino in Minnesota, and also a table game dealer in Mystic Lake Casino in Minnesota, and before that, he'd been a nursing assistant. Mr. Toma disclosed in his application that he had been previously licensed, and we confirmed he was previously licensed by the Iowa Racing and Gaming Commission, the Shakopee, Mindwakan, Sioux City Gaming Commission, and the Upper Sioux Community Gaming Commission. All of his licenses were in good standing, and all jurisdictions contracted reported no derogatory information relating to Mr. Toma's licensure. Overall, there were no significant investigative issues uncovered related to his application for licensure, and he has demonstrated by clear and convincing evidence that he is suitable for licensure in Massachusetts, and therefore the IAB is recommending the commission find him suitable for a key gaming license, key gaming executive license, pardon me.
Great. Comments?
You know, I thank you for the report. I think it's great. As I was reading and talking about this report, talking to Director Wells, it occurred to me that this is a great example of how these employment, these people, you know, these opportunities really are career opportunities. Mr. Thomas started as a nursing assistant, went to school to become a dealer, and is now a key gaming executive. And it just reminded me of the economic development that comes through the likes of this industry, and I just thought it was worth mentioning.
Great. Anything else? Thank you.
Okay, I think the
We
commission
need a
needs to
vote,
vote.
I think, right?
Oh, all right. Commissioner Stebbins?
Mr. Chairman, I move that the commission approve the Key Gaming Executive license for Mr. Toma.
Second?
Second.
Further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
Thank you. I'll coordinate with our licensing director about issuing the license for Mr. Toma. The next item on the agenda is an exclusion list process discussion, and I have Attorney Lilios, who submitted a memo to the commission for your consideration, is going to lead the discussion on that. I think there's some issues for the commission to consider when we go forward with the process for setting folks on the exclusion list.
Morning.
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 So the exclusion list that we're speaking about this morning is to be
Is your mic on? Okay.
Oh, there we go.
Needs to be
Is that
bright.
better?
Yeah, the green lights are deceiving here.
They are. So this exclusion list is to be distinguished from the voluntary self-exclusion list, and the persons on this exclusion list are placed there on the determination that they would pose some sort of corruptive element. The statute sets out a number of criteria for placing persons on this list, including that they've been convicted of a crime punishable by more than 6 months, they've convicted of a crime of moral turpitude, they violated the gaming laws, they have a notorious reputation that would adversely affect public confidence, that gaming establishments are free from a corruptive element, or their presence would pose an injurious threat to the interests of the Commonwealth because they are, for example, a known cheat or have a history of disruption to gaming establishments or are subject to a no trespass order from a casino. These lists in other jurisdictions are typically posted on the regulator's website, and our regulation does require that they be posted on our website, including a dated photo, if obtainable, and identifying information of the individual. A gaming licensee can be fined or have some other sort of adverse action against it if the licensee knowingly or recklessly allows the person to remain on the establishment and fails to exclude the person. Under our statute, if a person on this list does game, any winnings by this person are forfeited to the Gaming Revenue Fund. The IEB is looking for some guidance from the commission as to how it wants to implement Section 45 of the statute. Currently, when the statute is read in conjunction with the regulation, 205 CMR 152, the process would envision that the IEB, on its own initiative or upon referral by the commission or the casino, shall investigate anyone who may meet one of the criteria. So as an initial matter, the IEB is requesting an amendment to the regulation because as it now stands, the universe of individuals that the IEB has a duty to investigate is extremely large, given that there is a criterion of anyone convicted of a crime of punishable by more than 6 months. That is all but the most minimum crimes in the Commonwealth. So there is a suggestion in the memo about an amendment to that area, and also that sort of duty would not really have a correlation to the effectiveness of an exclusion list. It appears from my research with other jurisdictions that keeping these lists to a manageable number of persons can lead to their effectiveness in terms of being able to track and enforce the policy behind the list. So I actually have an amendment to my suggested amendment in the memo because the suggestion in the memo is just a straight out changing the shall to may, but mandating that the commission investigate any referral, mandating that the IEB investigate any referral by the commission itself is certainly something that makes sense. So the suggestion is that the IEB may initiate an investigation on anyone that may fit one of those criteria and shall upon referral by the commission. Under the statute in the existing reg, if the IEB, after investigation, determines that a person should be placed on the list, the IEB makes a referral to the full commission in writing with a factual basis for inclusion on the list, and then the full commission considers that individual at an open meeting. If the commission places the person on the list, only then, under the statute, does the person get notice of the placement on the list and an advisement that he or she has the right to an adjudicatory hearing before a hearing officer. The regulation gives the commission additional authority to give another layer of notice in its discretion in advance of the matter being brought before the commission, at which point the individual may request a hearing. And if the commission decides to go this route, the IEB would be looking for direction and some clarification on what type of hearing the commission might envision at that stage. The memorandum, the last paragraph of the memorandum that you have in your packet poses an alternative that does not run afoul of Section 45 of the statute. And the alternative would be to allow the commission to adopt a procedure whereby the IEB notifies the individual that the IEB intends to place the individual on this exclusion list. This notification from the IEB would advise the individual that he or she may claim an adjudicatory hearing before a hearing officer at that stage and before that placement. So essentially, that review by a hearing officer would be a review of an order from the IEB, which is an allowable matter under our hearing regulation. And under this procedure, all persons placed on the list would have prior notice of placement and an opportunity for a hearing before any such placement. And then if the if the hearing officer affirms the IEB's determination, the person would be placed on the list and the person could have an opportunity for review at the full commission. Again, that alternative comports with the statute, but regulatory changes would need to be made. There is one other aspect of the statute that I wanted to just bring to your attention, that the statute does call for the commission to establish a compact with other states for purposes of sharing information. The IEB is certainly already in the process of sharing information with other states, and we're in the initial process of exploring a more formal compact. It does not appear that any other jurisdictions have implemented a more formal compact, but those are the discussions that we are entering into now.
Let me just, if I get on the second issue, it sounds like you're asking for two things. One is that there be a notice to an individual in advance of the commission's decision to put him or her on the list, so that as soon as you would notify of the intent to put somebody on the list, and that's when there would be a hearing opportunity. But also, you're suggesting an interim step, which is a hearing officer hearing, rather than going straight to the adjudicatory hearing, which is what's in the statute. Am I right that those are the two things you're asking for?
The hearing before the hearing officer is the adjudicatory hearing. And the hearing regulation interprets the adjudicatory hearing before the commission to mean, in this instance, when it's review of an IEB order, to be a hearing before the hearing officer rather than the full commission.
So you'd substitute the hearing officer hearing for the full commission hearing?
That is the way the hearing regulation now reads. If it is an appeal from an IEB order, that appeal goes to the hearing officer.
It would somewhat mirror what we do with raising.
That's correct.
So the way this would work, as laid out in the third paragraph, is the person would get the notice, the person would elect or not to have this adjudicatory hearing before the hearing officer. That would be where evidence is presented, and the hearing officer would make a written finding of facts and conclusions, and either say you're on the list or you're not on the list. And then either the IEB or the person whose reputation was at stake could appeal to the full commission. But that appeal would be a public hearing. It would be on the record, but it would be a public hearing. But that would be the first time that the individual was seen by the public as the target of the IEB's reputationally damaging action.
Well, the first time the person would be seen would be when he's placed on the list, but yes, if he were to, so.
If he were to appeal,
Correct.
he would already have had the benefit of an evidentiary hearing,
Before
or
he-
she, before a hearing examiner, and would know that the next step would be a public step.
Correct.
But the statute, doesn't the statute say that the person has a right to an adjudicatory hearing before the commission?
Read in conjunction with our hearing reg in 205 CMR 101, the commission has already determined that an adjudicatory hearing before the commission in an instance where the individual is appealing from an order of the IEB means that the hearing goes not before the full commission, but to a hearing officer.
This is similar to the way it's done with other agencies. When there's a hearing before an agency, the MCAD works this way. The workers' compensation hearings are this way. The statutes may be slightly different, but this is not an uncommon procedure.
Well,
And it effectively would give the individual the right to 2 layers of hearings within our commission structure. So hearing officer and then to the full commission.
yeah, I understand that, but I'm wondering about whether we're within our rights to make the first one the adjudicatory hearing and the second one a public hearing. And where is the reference in our regs that you're talking about that in effect interprets the statute to make it something which can appear before a hearing officer?
It's 205 CMR 101. I did not provide that in your packet. It's another reg called, I think the caption of the reg is adjudicatory hearings, and I think it's the second full section. Catherine, I don't know if you can shed any.
Are those regs racing, stemming from racing regulation, racing statutes?
No, they don't. That we have a regulation that covers all hearings in front of the commission. It does cover racing hearings, but it's broad across the commission. And under that regulation, what we did was we kept certain hearings at the commission level. So hearings that impacted an actual Category 1 or Category 2 gaming license went to the commission first. A penalty that resulted in the revocation of a gaming license or a racing meeting license goes to the commission first. Every other kind of hearing goes through a hearing officer first with a right of appeal to the commission as a whole. And part of the reason for that is to get a situation where they can have a full evidentiary hearing in front of a hearing officer. They can take their time, it goes on the record, they can submit all kinds of evidence and testimony and do it that way. My concern, and I had conversations with Loretta, was that the way the statute is drafted in this situation, the person wouldn't be entitled to a hearing in front of the commission until after they went onto the list. That's the way the statute's drafted. And I'm a little concerned about, as Commissioner McHugh pointed out, potential reputational damage with a hearing after the fact. So we thought that in conjunction with our hearing reg, which is clear that this kind of a hearing can go to a hearing officer, we would do notice first. That would be an order issued by the IEB. The notice would be there. They would have the right to a hearing in front of a hearing officer. At that point, the
Which
hearing...
would be adjudicatory and private.
Yes, yes. And then at the end of that hearing, if the hearing officer affirmed the IEB's recommendation, it would come up to the commission for final placement on the list. At that time, in a public meeting, that person could come forward. They could present evidence again if they like. If they choose not to, they can. And the commission could determine whether it goes on the list or not.
Well,
Stays on the list or not.
Well, it won't go on the list until after there's a determination by the hearing officer. If we do it in this alternate procedure that has been proposed, we would only get a notice of intent from the IEB to place the person on the list.
well, let me say, first of all, I'm not sure that this scheme is a departure from the way the statute is drafted. We can't depart from the way the statute is drafted. And I think that the notion that the adjudicatory hearing has to be before the commission includes an adjudicatory hearing before a hearing officer. That's the way it works, and I know that we don't disagree on this, but I want the record to be clear. That's the way we are interpreting the horse racing stuff, and we set up this hearing officer appeal to the commission regulation to talk about, to deal with a broad range of things that the IEB has the potential to do. And all of those things ultimately wind up before the commission. The second thing is that the hearing, that the piece of this that's before the full commission is still part of an adjudicatory hearing. It's an appeal from the fact-finding hearing, and we treat it just the same way we now do the racing. The racing hearing takes place before the hearing officer. We get it on the record. We get submissions by the lawyers or the individuals on both sides. We read that. We talk about it. We talk with counsel about it, and then we have an opinion that issues either
So
affirming or denying.
That would not be public.
That piece would, we could make that piece public, but we wouldn't have to make that piece. Certainly, the piece that would be public if we provided for an opportunity for the lawyers to be heard, and also the person who was the target to be heard. We do that now, I think, with respect to racing hearings, but nobody accepts. I think we've had somebody that actually accepted an invitation to talk to us about a racing matter. But but this is a guidance exercise. We could have it public or an opportunity to be heard by the lawyers, but no further evidence.
But the list obviously is public once a determination has been made to place that person on the list.
Yes.
Obviously.
I have two concerns here. One is the process itself, the idea of having a hearing officer hearing first, in theory, is perfectly reasonable to me. I'm not sure that it fits with our statute. Commissioner McHugh says it does, and everybody else does it, but I would want to, it doesn't make sense to me, and if we do indeed have the right to write a reg which makes a hearing before a hearing officer and adjudicatory hearing before the commission, even though it's before the person has been placed on the list of excluded persons, I don't see how that fits. But if if MCAD has similar language and has done the same thing, then I'm wrong. So that's one issue, is do we have the right? Are we following the direction in the statute properly? Number one. If we are, my only other concern is that we've had a problem with erasing of the lapse of time between the event and the final resolution. And we've talked about this, and we're trying to improve it. Everybody's aware of it. Nobody's at fault. It's a complicated process. And I don't know whether it's a little bit different in the case of if somebody gets kicked off a track and can't do their life's work, to have that appeal take 8 months is really problematic. Here, I guess if you aren't on the list yet, so I guess it really is prejudicial to us, not prejudicial to the person. But I do think that somehow having this process be expeditious is important. We got to try to figure out how to make this really move. So I guess my issue really is the legal one. Does this really fit within the language of this statute on the two scores, adjudicatory before the commission and after he's been placed on the list?
I did really struggle with the first question in the past couple weeks, and I am comfortable with it now, and I think if you have the statute in front of you, it's in your packet, subsection D. I think part of this requires that we interpret the word commission, the small c commission, that can be delegated and is delegated by our regulations, although we could look at whether we need a specific delegation in this instance. But if you look at subsection D and read it as IEB instead of commission, so whenever the IEB places a name on the list, the IEB has to serve the notice, and then looking at the next section, within X days of the notice, the person gets an adjudicatory hearing before the commission, and again, read in conjunction with our other hearing reg, commission, I think without running afoul of the law, is interpreted, since we've got an order of the IEB, orders of the IEB get appealed to a hearing officer.
I thought it was intent. You were notifying the person of intent, not that they're on the list.
Well, it would be viewed as a preliminary order. So it would be an appeal from a preliminary order of the IEB.
Okay, but that's different.
So-
It's not different. I mean, I don't mean to jump in this, but I don't think it is different. And I think one has to look at what the legislature undoubtedly intended here. The idea that government can take an action against an individual, label the individual as a cheat and a crook, publish that person's picture on a website where it's available to everybody, and then say, okay, now you can have a hearing, is a monumental invasion of the rights that an individual has in our society. I think that and I think it may rise to a constitutional level. And I think that one has to take a look at what the legislature intended in a light that saves it from possible constitutional infirmity. And this solution, it seems to me, does. Whether we should do some more research to find out what other agencies do is something that may well be worthwhile. But I think the bottom line is taking a look at the big picture of what the different interpretation of this statute would entail, and I think it is monumentally unfair.
How does it work in other jurisdictions? When in the process does someone have a right to an appeal?
They're notified prior to being placed on the list. But it's sometimes advertised in the paper when they're being placed on the list because they haven't been able to track the person's address.
Well, that's a little different if you can't reach the person, so is what you're saying that Commissioner McHugh is right in effect, that in standard operating procedure in other jurisdictions is that a person, if possible, has an appeal right to a private appeal before they are put on the list?
I know in New Jersey it works a little bit different because that order to be placed on the list is actually made by the commission itself. The evidence is presented to them, they voted a meeting, and the person's going to be placed on the list. I'm not really sure a lot of the other jurisdictions.
I've looked at 4 other jurisdictions, and it appears that in all of them, there is some sort of notice and an opportunity for a hearing in advance of actually publishing the information on the exclusion list. So all of the statutes nothing lines up exactly with our statute. Sometimes the hearing is before the full commission, sometimes it's before a sub-body or some sort of hearing structure, but there is always notice. In what I've looked at, there's notice and an opportunity to be heard in advance.
Isn't the threshold pretty high, in terms of the directive to the IEB as of when somebody's a known cheat, when there's this big disrepute that could come to the Commonwealth, that's a threshold for beginning action.
Well,
And I know, but I do understand, and the fundamental point you make, Commissioner, but I read it as a very high threshold.
6 months in jail is really a pretty low threshold.
And it's, if I may, it's not even served 6 months. It's convicted of a crime that is potentially punishable by 6 months.
But you're switching shall to may, which does raise the standard. That's the
Yes.
whole point, is it raises
Oh,
the
good
standard.
question.
I like the process. I prefer this process because of what Commissioner McHugh was saying. I was concerned that it may not fit within our statute, but if you're telling me as a judge that we can have the right to deduce what they must have intended, even if it at one level doesn't seem to say that, then I'm fine with that. I don't know who's
I
going to
think-
object.
Well, I'm a commissioner here.
I think, Chairman Crosby, it might be easier to think of it not so much as doing something different, but adding an extra layer of protection, which I think the commission has the ability to do. Because if you look at the statute wouldn't have the hearing until after notice. We're just adding in an extra protection before notice. So really, they have the potential for 2 hearings. So I think it's an additional safeguard. I don't think it's so much that we're doing something, completely opposite of the statute. We're building in an extra protection, which, I think is fair, given the low threshold in the statute.
But there are two fuzzy issues, as I've heard you talked about this. Is this in order to put you on the list, or is it an intent to put you on the list? Is it a prelim, I don't know what, you've said 2 different things as I hear it. And is the meeting before the commission a private meeting or not? And I think initially you said it was a public meeting. Now I'm hearing it could be either. So those 2 things need to get clarified.
And the regulation, as it now stands, says that it's a public meeting before the commission, but if we go this route that we're evaluating now, we'd need to redraft the reg, because the reg does not cover this alternative.
If there's a way to do what Commissioner McHugh said, which is make the hearing and the hearing officer hearing, and the public hearing, and the adjudicator, and the meeting before the commission, if you could make those 2 things the same meeting, sort of an extension, then it could be adjudicatory, at both levels. At least the applicant has the right to an adjudicatory hearing at both levels. then that would work. But I just think, one way or the other, those two things have to be clarified.
I give deference to this alternative. But proceeding through this process, let me just lay out a scenario, and Bruce and Burke, your experience may help give me some guidance. Any of our licensees can automatically remove an individual who would fall under this criteria at any time.
Yes.
So it's not just waiting for us to, what I see is we're going to have to
Through the
populate.
Landlord Act, yes.
Right, we're going to have to populate our own list, basically. I mean, the compact is good because we're going to be sharing information with other jurisdictions, but not wholesale adopting everybody that's on their list.
Right.
It's going to be up to IAB and our team. So as long as the licensee can remove anybody from their property while this process is being undertaken, my only other concern, and again, I do favor the alternative, is there any need for this commission to retain any authority that if we know number one primo bad guy is about to walk through the doors of Plain Ridge, that we can take swifter action, or does that action somewhat leave itself with the licensee, knowing the process that we've laid out?
Yeah, a lot of times these cheat teams and stuff that you kind of know through intelligence are coming to your jurisdiction or
Right.
something. I could see a case where you might want to make it for, you don't let those people in. But I think you could probably still do that at the casino level, to identify them.
Doesn't the casino always have the right to exclude any
Yes.
person
Right. Yes.
from the premises it
Yeah.
wants to?
Right.
Yeah.
Right. So the answer is right, that the casino does have the
The
opportunity.
casino does have,
notwithstanding
I'm
this.
just, and again, notwithstanding our process for the points that Commissioner McHugh made, I would worry, I'm just wondering if we should reserve the authority in those, and let's hope they're extreme cases of bad group of people working their way up the coast, and we're left to defend ourselves and say, well, here's our regulatory process, where we lose the authority to really interject ourselves in a case that's obviously visible and clear that we don't want these people walking through the door, and not necessarily just put that burden completely back on the licensee.
We could think of a provision for imminent, if there are facts that show imminent entry by,
There may well already be
Yeah.
something written down somewhere that says,
Yeah.
I'm sure there is, that says that they have the authority to prohibit entry to anybody they want to, within, certain reasons. And I'm sure there's no reason why our security people can't talk to their security people. So if it's already there, you might want to, just to make the point, you might want to say nothing here, counteracts that pre-existing authority. But it's probably already pretty clear.
So I think ultimately, the IEB is looking for some direction for the commission. Attorney Lilios, sort of presented two options. What I hear the commission saying is we'd like to consider that second option where we have that added protection and notice to the individual. So I think the next step would be to draft a proposed regulation to come back before the commission for the commission's consideration of that draft regulation. Am I correct in my understanding that that would be what the next step, and that's what the commission would direct the staff to do?
I would support that.
Yeah, I don't hear anybody objecting to the process. It's a
No.
question of, the details.
And then
And
Yeah,
we-
but, and that is the second alternative with the hearing officer.
Correct, correct. And we can certainly flush out some
Yeah.
more details on other jurisdictions and work on the details of the language to address any concerns, relative to the statute.
And I didn't hear anybody objecting to the shall to may issue change.
No, I just wanted to invite the consideration of having the shall include a reference by the licensee,
okay?
Yes.
Okay, that makes sense.
taking account of what we were just talking about here.
Right.
Yeah, I agree with that. I'm also, this is not a matter for today, but I would be interested, of course, in that hearing officer. I would assume that it would be somebody similar to who we have now, with some relevant experience, but not certainly not somebody at IEB.
Oh, no, it's an independent hearing officer. Our
Right.
current hearing officer is getting up to speed on gaming issues, so he's being trained, but we can also bring additional part-time hearing officers on if we need them.
Right.
Okay.
All set on B?
I'll-
Let's take a quick break
Okay.
before we start C.
Thank you.
Could take a little while. Thank you.
Thank you.
Thank you.